Thank you, Dan. So thank you for coming back from lunch. It's, as Aurelio has just said, the siesta slot. So try to keep up. So very fascinating morning we had, but I gather from Dan's remarks earlier that yesterday was exceptional. Unfortunately, I couldn't make yesterday, but next time, perhaps you could give me a little warning as to which day will be the exceptional one. I feel a slight victim of information asymmetry there. And I misallocated my resources in terms of attendance. So anyway, this afternoon we are going a little bit out on a limb in terms of the topic, insolvency, and we're also moving a little bit, I think, fair to say, geographically southwards in Asia, to Southeast Asia and South Asia. So we have Surbhi Kapur from Jindal, who's going to present on an aspect of insolvency, and I think the words workers and employees come into it, so that's not a phrase you hear too much in corporate law forums, I guess. But so a little bit different in that sense as well. And then Aurelio, who's a currently SMU professor and doubtless one day Chicago professor, will be commenting. So that should be interesting. All right. Surbhi.
So I'll be discussing the social dynamics of corporate insolvency law as far as the claims and entitlements of employees and workmen are concerned. Both of these are distinguished, like you may want to use them synonymously, but they are very different when it comes to the benefits that they can get when it comes to the structure of liabilities in the order of priority. I'm using these terms, but I'm going to employ them while I'm going to explain about how the waterfall of liabilities is worked out in different jurisdictions. And this is relevant because I'm going to disprove or in fact refute the creditor's bargain theory, that is the prevalent theory which focuses on the creditor-centric outcomes when it comes to corporate insolvency law, and particularly the distressed entities and how the outcomes are worked out in accordance with that theory. So I'm using the normative social policy theories, a bit of those, and juxtaposed against the creditor's bargain. And little bit I'm going to disprove, I'm going to try doing it. Obviously, Aurelio is going to review my paper. So yeah, we'll see about that. So coming to the agenda for my presentation, I'll start with a bit of an introduction, then delving into the research objectives and questions, the methodology. Then the first section of my paper discusses the very nature, the intrinsic nature of insolvency laws, and that would be discussed with respect to the social welfare attribute of the law. And I have two sections right there. One is how the entitlement and the claims or the rights of employees and workmen have been worked out in the international soft law discourse. That's one. And second, something which is very interesting for me as well while I was doing this research was to assess insolvency regimes and to theorize data about social welfare outcomes of such regimes, because that is something that I'm relying heavily upon. One of the research studies conducted by the International Monetary Fund and the OECD way back in 2018 and 2019. And I'll be discussing a bit about that. And in the core section of my paper, which is about comparing select Asian jurisdictions, I have delineated it across 5 sections with respect to the applicable legal framework, the connotation, the standing of the different stakeholders, primarily the twin stakeholders which are under discussion here, then the type of claims that are addressed by the insolvency courts across the world, primarily focusing right now on the Asian jurisdiction, and finally, I conclude with the way forward. So now, an interesting picture on screen wherein I start my paper by alluding to this very famous poem. I'm sure many of you might have read it in the school, which is The Rime of the Ancient Mariner, which is by Samuel Taylor Coleridge. It's like water, water everywhere, not a single drop to drink. It's like one poem. Maybe all of you might be aware of that line that I have borrowed from that poem. And it kind of, it paints on canvas the trials and travails of a ship en voyage, and how the different stages that are being discussed and portrayed in the poem, they ultimately narrate the series of events that led to the sinking of the ship. Now, I draw an analogy from that poem and the different stages that have been narrated in that poem to what has been the picture of two big shipyards in running into insolvency or bankruptcy, whichever way you may want to use the term for. I'm going to use it interchangeably here. So when it comes to the ABG shipyard, it was one of the largest shipyard firms in India. And it was one of the, the dirty dozens, the 12 large accounts that were referred by the Reserve Bank of India ostensibly at the instance of the Prime Minister's office in India, that ran into insolvency. And a lot of attempt was made to salvage it, and but it sunk into an ocean of debts and it was liquidated. And why I bring to the fore this particular case is the fact that there were about 873 employees and workmen who were not paid their salaries for a period of 5 years since the start of insolvency, that is the insolvency commencement date. That is the expression we used in the Indian legal discourse. And for 5 years, they were left in the lurch. The financial woes of those workmen and employees, despite being, knocking on the doors of the courts, they were quite unsure and to no avail. However, last year, Supreme Court rendered a landmark judgment in our in this matter, ABG Shipyard, in the liquidation of it, and addressed the claims of such workmen and employees, and they were given super priority, as we shall see as I delve further into my research here. The other instance that I have, brought on record here is the Shipbuilding Industry Corporation in Vietnam. Recently, it has also sunk into an ocean of debt, wherein all of its assets are now going to be realized towards the social insurance of workers, the debt repayment, and also for the outstanding salaries. Now, formerly it was known as Vinashin. Now it's SBIC. And primarily, why I bring this example is that workmen and employees, they are in essence the lost souls of insolvency law. Now, why do I say that? Because, we say in Insol International, there's a paragraph that says that they are the lifeblood of an enterprise. And, ArcelorMittal report, if you refer to the annual report of ArcelorMittal, which was one of the resolution applicants, the successful resolution applicants in one of the very important matters of SR Steel in our country, again, very high stake matter, they're just unsure about how their claims would be realized when it comes to a distressed entity, wherein they have devoted years of time, effort, their sweat and blood in building that entity, and they are absolutely unsure about their service-related claims, about their welfare claims. So it's like they're absolutely lost about where they stand and what their standing is. So in this vein, we all should be mindful of the fact that law is a function, a larger part of the societal whole. And humanization, I lay emphasis here on this term, is a cornerstone of the legal ability, of the law's ability to ensure public welfare. It cannot realize economic outcomes at the cost of compromising the social welfare aspect of the law. So in that vein, why is this germane here is because we are talking of corporate law. We are having a very good discussion since the past 2 days, but in today's time, corporate law has actually transcended the traditional shareholder wealth maximization paradigm and has espoused the heterodox stakeholder approach. Now, this this primarily is, incorporated in various statutes of the Asian jurisdictions in the form of various legal drafts that we see, wherein we see an erosion of the limited liability concept for the benefit of the stakeholders, for their protection. Then, we talk about ESG, the turn towards sustainability. That again is a part of the heterodox stakeholder approach that we are, referring to. Then again, also the social and distributive justice oriented outcomes that we talk of when it comes to corporate law in general and corporate insolvency law in particular. So we need to focus on all of those fronts, and that has actually led to a broadening of the social purpose, the corporate social purpose, in terms of, I'm going to focus more on the insolvency and bankruptcy front, because it is all about timely gauging the viability or the sustainability of an enterprise, because you know that, okay, it's no longer serving the public interest, so you would want to recycle its resources and reallocate it for a better purpose. That's what the function of insolvency and bankruptcy laws entails when it comes to the broadening of the corporate social purpose, because you are ensuring and bolstering the freedom of exiting the cycle of failure. And that is the main function that the insolvency and bankruptcy laws serve. And how a company, when it is in a distressed state, navigates the relationship with all the stakeholders across the board, be it the employees, the suppliers, or for that matter, if you look at the creditors' bargain theory, the creditors primarily, is what is, the central question that goes behind analyzing the S and the G in ESG related discourse, and that would ultimately lead to ensuring the survival of the debtor. Or you say, in different jurisdictions we say reorganization, rehabilitation, or recovery of business operations. That's how, the different jurisdictions employ the terms for survival of a debtor, a corporate debtor per se. Now, in terms of my research objectives, so going beyond the neoclassical paradigm where, the workers and employees are merely looked at from just factors of production thought, this research focuses on the human and social dynamics of corporate insolvency laws in their applicability to the workmen and employees. It discusses the prevailing normative theories and policies juxtaposed against the creditor's wealth maximization paradigm. And it assesses how effectively the Asian insolvency law systems, they, serve the notions of social justice, and as against, purely fostering economic efficiency. I would want to redefine this term to ensuring socio-economic efficiency right here, and how the interplay happens between the social policy objectives and the insolvency laws, qua the entitlements and rights that, workmen and employees may enjoy being the non-consensual creditors. So now, coming to the contribution to the discourse, unlike the extant literature where I cite Aurelio and many other people that focus on, the duties of directors only with respect to the financial creditors of a company, this research, it advances a novel interpretation of such a framework wherein it explicates on the creditor duty of the directors of an insolvent company, qua the workmen and employees as service or operational or internal creditors of a corporate entity. And this is owing to the fact that there is a change in the status of such, stakeholders from their status ex ante to ex post. So this aspect, I feel, has largely bypassed the attention of several researchers. So that is the contribution to the discourse. Now, I'll briefly cover the nature of insolvency laws, qua the social welfare attributes. So, like I was saying, it's all about freedom of exit, how you foster it, and you basically want to bring out an entity out of the cycle of failure. And we need to reassess the nature and the role and the goals of insolvency law in this respect in terms of the socio-legal discourse that we have, as against the internal and external aims of insolvency law. So internal aims primarily encompass the commercial attributes of insolvency, wherein it focuses more on, the creditor's bargain theory, wherein you would want to maximize the wealth and collective return to the creditors, and you want to preserve the ex ante status to the creditors, right? That's what is the internal aim of the insolvency law. And when it comes to the external aims, it's all about balancing the interest of all the stakeholders, be it employees, be it workmen, be it your suppliers. And so there, two competing camps have emerged as a result of all of this discussion behind, discussing about the social welfare attribute. One is of the traditionalist and of the proceduralist. While traditionalists, they espouse the social welfare character, proceduralists say that, okay, there's nothing magical about insolvency law as a savior of, employment or preservation of human capital. It just is something which is a procedural law, and it has to be worked out in that way. And it has led to a convergence of approaches where there have been many, approaches that have underpinned the social welfare character. Because of paucity of time, I'm not going to cover all of this. And now coming to the comparison which I have undertaken of the various jurisdictions. From that, I could cull out the legal sites of protection when it comes to the workmen and employees. So in some jurisdictions, they have been given the status of a creditor, for example, in India, Singapore, and Vietnam. And they can as well initiate proceedings for the resolution of the corporate entity where they have been attached to. Then they have also been situations where the representatives of employees, they participate in the meetings of the creditors committee, which is one of the most important decision-making institutions when it comes to resolving insolvency. And it kind of gauges the feasibility and viability of the resolution plan. That's what we call it in India. It could be, it is called debt restructuring plan or rehabilitation plan in Singapore and Vietnam respectively. And how, dues of the workmen and employees as creditors in that way have been accorded a priority, a pari passu treatment. For example, in India, they have been afforded a super priority when it comes to, if they have contributed to keeping the corporate entity afloat. And yes, and they also stand prior to the floating secured creditors. And specific insolvency funds have also been carved out in various jurisdictions, for example, Hong Kong and Thailand, to offer relief to the workmen and employees. So I'm going to skip this because, again, I've been shown the card. So okay, this is important because I'm assessing all of these regimes here, that how, the data is collected by different regimes in different jurisdictions across the world, specifically in Asia. But what is to be noted is that no stakeholder data per se captures the phenomenological experience of employees and workmen beyond the numeric point. So you focus on the realizations to the financial creditors, but what has been the experience of employees and workmen? How much of a haircut has been has unveiled when it comes to realization of between the admitted claims and the, the realized claims. So that research has not been conducted. I start with, okay, I've also collated some recent research that looks at, the post-resolution, the post-bankruptcy effect on the employees and how it works out eventually. And I'm going to cite just one study from India, which was conducted in the year 2022, which says that there has been an increase in the average employee expenses, and there has been a substantial increase in the employment when it comes to the post-resolution period. And so in our jurisdiction, it has impacted industry growth. All of this has been captured by the data. So I'm going to talk of the data captured in Hong Kong, which is as a result of the Protection of Wages on Insolvency Ordinance. And they capture the data pertaining to, the number of applications that have been received, then, the amount of ex gratia payment that has been sanctioned, has been rejected. Basically, it is for employees of insolvent companies. And they also do a delineation across sectors, as in, which sector has received the highest number of applications in order to just to improve the working of the law. And now coming to India, again, India, there has been many cases that have been admitted. And, but again, they have done a sectoral distribution. However, if you look at this data, which has been collated, I've taken it from the newsletter that is published by the Insolvency Regulator of India. You see that there have been substantial haircuts. Haircut is an expression that is used in India just to, explain the difference between the admitted claims and the one that has been realized after resolution. So that is the haircut. And if you see the entitlements in under section 53(1)(b) and C, you see how much of it is realized and how much of it actually is, was admitted. amount of claims which were admitted and how much has been distributed, there's a vast amount of difference. So that actually shows that there has been a substantial haircut which is meted out to the employees and the workmen. And now comparing the jurisdictions, I'll just give me just 60 more seconds, I'll wrap up. So the applicable legal framework, I've just tabulated it that these are the applicable principal insolvency statutes across various jurisdictions that I'm comparing, and how the workmen and employees, their claims are handled. So they are internal creditors in all the jurisdictions, and they are empowered, in some jurisdictions they are empowered to initiate resolution process. And IBC in India, it creates a class within a class by a differential usage of employees and workmen, and obviously their benefits vary. And coming to, right, as creditors, they can petition. And okay, I'll just wrap up with a little bit about the claims of workmen. So when I was doing this research, I found that, we talk of all these entitlements and claims, but we do not differentiate between those which are service-related claims and those which are welfare claims. So one of the landmark cases in India, it differentiates between the service-related claims and the welfare claims of employees and workmen. So service-related claims are those that are, that arise during the subsistence of the employment of a particular employee or workman. And when it comes to the welfare claims, it is after the employment is terminated, or for that matter, cessation of employment. And jurisdictions employ preferential status to all the workmen and employees. Some jurisdictions do that, some do not do that. And order of priority, I've just discussed it briefly, that their dues rank second and third in the waterfall of liabilities in most of the jurisdictions. And right. Okay, the other bit which I was discussing, I think I've just briefly touched it while I was discussing the objectives, the director's duties vis-a-vis the workmen and employees. So we need to expand upon those duties because they're only owed to the financial creditors. And finally, I would want to wrap up and say that, we need to strike a balance between the, the rights of the workmen and employees and of the other creditors as well, in light of the differentiation that is drawn between financial and service and operational creditors. And also, I feel that, we need to have more data-centric regulation, because how would we gauge the working of the law otherwise? Because if the outcomes are not published or not known for that matter, then it is, I think the exercise is in vain. And we need to regulate the haircuts, and we need to have employee voice in resolution. I understand that there's a lot of delay, protracted litigation that happens across the world because, courts are saddled with so many cases and there's a lot of errors, but still, we do need to have employee voice in the resolution, because otherwise, the greatest stakeholder who knows in and out of the organization, if they do not have a say in the creditors committee, then I don't think so a successful resolution actually balances the interest of all the stakeholders. Thank you.
Thank you very much.
So when he was speaking about the purpose of the corporation, he started by speaking about Milton Friedman, right? And we all know here that Milton Friedman said that the sole social function of a corporation is to maximize profits for the shareholders. Well, my views on this is that the sole social function of insolvency law is to maximize the returns to creditors. So that's why Stephen was making fun of me. So just to be clear, full disclosure about my views on insolvency law, and the purpose of this is to convince you why, if you want to promote growth, why, if you want to protect employees, why, if you want to reduce poverty, what you need to do is to maximize the returns to creditors. But that said, the paper very fascinating, covering the notion of public interest, a human and social perspective of insolvency law. But here is a very interesting example, which is mentioned, oh, I don't know what happened with the slides. So a very interesting example that is mentioned in the paper, providing two scenarios. That this is actually taken from a professor from Yale, if I'm not sure. And it's actually something that is going to be very helpful to make sure that you guys are sleeping or not, because I would like to hear your views. Imagine that you were a bankruptcy judge, and before you, you have an insolvent company, and you need to decide what to do with the company. And imagine that there are two options. First, so you can keep the company alive, and the creditors will get $1 million. Option two, so the company should be liquidated, shut down, and then the creditors will get $1.5 million. So you guys are the bankruptcy judges. What would you do? So raise your hands, those of you in favor of option one. Let's keep the jobs, let's keep the company intact. Raise your hands. Wow, how many people here supporting your views? Okay, those of you say no, we should shut down this company, we should liquidate the firm, and then to maximize the returns to creditors. Raise your hands. I can see my friend there, Akshaya. Thank you so much. More people, wonderful here. Okay, so wonderful. So this is what I'm going to discuss, actually, and this is what the paper really discusses. Okay, that's a very good. So we're going to briefly discuss that in a minute, but this is actually what the paper is really about and what this discussion is really about. So we have been speaking for the past couple of days about the purpose of the corporation, how directors' duties change, etc. Well, in insolvency law, we have exactly the same debate. The purpose of insolvency law, the purpose of insolvency proceedings. The calling mayors of insolvency law are the traditionalists. And their names are Elizabeth Warren, Jay Westbrook, Korobkin, and many others. And the Bebchuk, Friedman people of the insolvency law are Professor Douglas Baird, Thomas Jackson, Bob Rasmussen, and many others. And they are called proceduralists, not because they are proceduralists, actually, but because they see insolvency law and insolvency proceedings just as a mechanism, as a proceeding to solve an economic problem, to solve a collective action problem, and to help the creditors collectively decide what is the most efficient deployment of the debtor assets, and that is going to maximize the returns to creditors. So that's why we have had this debate in insolvency for a while. So this debate between Warren and Baird started in the 80s and 90s. So that's why something that the paper mentioned is that this public kind of function of insolvency law hasn't been very much explored. I'm not so sure about that. I think that many people have been writing about that, but it's true that nowadays, so there is, again, back the discussion because of the ESG. So the ESG that we have been discussing in corporate law, we have the same thing in insolvency law. Now, the big topic is to write about insolvency and ESG. And actually, so the paper mentions that there is these conflicting goals of insolvency law between maximizing the returns to creditors or doing what is best for society. Well, I don't think so, because what is best for society is actually to maximize the returns to creditors. And why do we want to do that? Because by maximizing the returns to creditors, lenders, from an ex-ante perspective, are going to be more willing to extend credit at a lower cost. Companies will raise more funds, they will create more jobs, and they create more wealth. So that's why sometimes by promoting a solution that can help us save a few jobs, and I say a few jobs because in some countries, for example, even Thailand has on average about 40 reorganization proceedings a year based on the statistics that I've seen. Ecuador has had on average 1 reorganization proceeding per year in the past 20 years. So that's why if we choose option 1, we might be helping the employees of that single company that initiate an insolvency proceeding, but we're going to be harming the whole economy. Because I always start my insolvency course by telling my students that insolvency law is not about insolvent firms, it's about the solvent world. Because depending on how you are treated in insolvency, as a creditor, you will extend credit or not at a higher or lower cost. And depending on how you're treated in the hypothetical event of insolvency, as a debtor, if you might end up in jail, for example, so of course that will reduce the level of risk-taking, that will affect your financial decisions, that will affect innovation. So that's why I don't think there is any conflicting goals. What is best for society is precisely to maximize the returns to creditors. But if we believe that we should reorganize non-efficient firms, non-viable firms, that's a separate discussion. I will get into that in a minute. But additionally, one way to save jobs And by the way, I think it's important, the paper focuses on preserving jobs of insolvent firms. But I think that when we think about jobs, we need to think about jobs broadly understood. Creation of jobs, preservation of jobs, and reallocation of jobs. So I've just mentioned how to create more jobs, which is maximizing the returns to creditors. But if we want to preserve jobs of insolvent firms, there are more ways to do so, not only by keeping firms alive. Because even if we liquidate the company, even if we dissolved the legal entity, we can still sell the business as a going concern. So for example, through a distress M&A transaction, and we can keep the whole workforce. So that's why reorganization is not the only way to keep jobs. But even if we agree that, okay, even if the company is not viable, let's keep the jobs. Well, first of all, that solution is going to be feasible and desirable in the short term. Why do we want to keep maybe the jobs for the next 2-3 years and at the same time doing something that is going to be inefficient and increasing the cost of credit? So that's why I think maybe the paper needs to maybe think a bit more about the viability of firms and the cost associated with keeping non-viable firms alive. I'm not saying that all non-viable firms should always be liquidated, because sometimes there are some country-specific factors that we might need to consider. So for example, the labor market and the rotations of how easy it is to get a job for the employees. So, I mean, there are some macroeconomic circumstances. This professor from Yale that I mentioned before with example, he also spoke that in some financial crisis, maybe it makes sense to sacrifice the most efficient solution as a way to preserve some jobs because of the macroeconomic circumstances. But as a general rule, I don't think that employees should have any say on insolvency proceedings. Basically, just to summarize my views. And also, I saw my name cited there somewhere in the paper saying, some authors have argued that the director should only, consider the interest of financial creditors. By the way, I didn't say that. I said the creditors as a whole, not financial creditors, the creditors as a whole. But should the director consider the community, saving the planet, and all of this stuff? The answer is no. But that said, I think it would be important maybe for the paper to clearly distinguish the role of employees as creditors, because they are actually creditors in many cases because they have unpaid wages. And as such, of course, they should have a major role in insolvency proceedings because they are creditors. But if they don't have any unpaid wages, so just because they provide labor, should they have a role, a say on the fate of an insolvent firm? I don't think so. But again, maybe there are some country-specific factors that we may want to consider when analyzing this decision. And that's all from my side. But again, I would like to start by congratulating you, and thank you so much for a wonderful paper.
Okay. So does anyone have any questions on either presentation? On either presentation, yeah. Wei.
Okay, fascinating paper, fascinating comments. Excuse me, I have a question actually to Aurelio. I mean, so I agree with many of the things you said, but the point is very simple. So if you give little say to the employees, you will increase the cost to high employees. I mean, I'm not talking about for this particular company, I'm talking about, for the overall sort of economy. That basically means the labor cost will be higher because labor needs to compensate it for those extra risk, right? So it seems to me the answer to your question is not so clear-cut. Eventually, it depends on the elasticity of the supply of labor versus elasticity of supply of capital. So I think the question probably should have different answers in different countries, different markets, depending on the relative elasticity of these two factors, right? If in a market, probably we have a smaller sort of elasticity of labor supply, that means basically we should give more say to the laborers. Therefore, overall, the cost of running the company will be lower. Therefore, we can have a more, companies make, greater wealth, right? I mean, that's the simple sort of logic. So that's my point. I don't know what's your response to this.
Yeah, so in fact, there are some empirical papers showing what you are mentioning. That if you maximize the returns to creditors, ex ante, that will increase the salaries for the employees. So it's even better for the employees to maximize their returns to credit. For the employees of the whole economy, not the employees of the insolvent firm. So you're right, but of course that is assuming that the employees will have some bargaining power. So that's why, so this is one factor to consider. Maybe other type of employees that cannot negotiate.
I guess if that's the case, that's just empirical sort of proof to show overall the elasticity of capital is smaller. So it's basically the capital in overall, it's in more scarcity, right? So that's why we need to, I mean, that's, that's the fact of the matter, right?
And in fact, one of my comments is that, I mean, these are my views, but I understand, and because of my research also in corporate and insolvency law, always incorporate country-specific factors that might affect the desirability of a solution. So if we were in a country where it's very difficult to find another job, so the labor market is very inefficient or you don't have enough kind of rotation, then that might support maybe the argument that we might sacrifice some returns to creditors. But otherwise, in fact, in a forthcoming book on insolvency law in emerging economies, I even say that insolvency law should not even reorganize companies. That shouldn't be even a goal of insolvency law. It should be only to maximize the returns to creditor, because that means that insolvency law should always be promoting the most efficient reallocation of the debtor assets. And that means that if you are worth more alive than dead, the most efficient deployment of those assets is keeping the firm alive, meaning reorganization. But not because we should reorganize insolvent firms, but because that's the most efficient deployment of the debtor assets.
Well, I don't agree with that, because I think we'll have to amend all the laws, the governing scopes across the board, the preamble statements everywhere. I'm saying, okay, so that's different, but I think that reorganization is really vital. And instead of only liquidating and focusing on, discarding the deadwoods out of the system, there's a lot that's involved when it comes to, reorganizing a particular distressed entity. And a lot many endogenous and extraneous variables function. So it may not be, only because of some, malafide when it comes to the directors or the board, for that matter. It could be some other reasons as well, change in policy or anything. That's the basic, like we discussed when it comes to insolvency law. And for the solvent world, yes. So, yeah. So we need to focus on reorganization and give them a second chance. And specifically when it comes to honest entrepreneurs. So, yes, that differentiation has to be struck. Thank you. In all the emerging economies.
And advanced economies too. So my argument applies also. We don't need reorganization proceedings unless it is the best way to maximize the returns to creditors. So just to clarify, I'm not saying that we should abolish reorganization proceedings, even though some scholars have said that. What I'm saying is, in terms of goals, normative goal of insolvency is to maximize the returns to creditors. Because if you do that, that means to maximize the efficient allocation of resources. And that means that if the company is viable, by definition, the company is worth more alive than dead. Exactly. So that's why reorganization should be a shift, but not because insolvency law should reorganize companies, but because it should maximize the returns to creditors. And in the context of viable firms, the best way to maximize the returns to creditors is by reorganizing the firm. And that's why you should provide companies with the right tools to achieve an effective reorganization.
Hi. Professor Martinez's excellent question inspired me to raise my question to you. Which country would you like to work? In Japan or in the United States? The first choice is like a Japanese choice. And the second choice is similar to the US choice. Yesterday, in my paper presentation, I mentioned about Japanese lost 2 decades. And one of the reasons is the illiquidity of the labor markets. And another reason is illiquidity of corporations. Japanese banks and actually Japanese Ministry of Finance hate to let the small company fail. Pressure the banks to keep lending to non-viable firms. So no liquidity of corporation and their resources. That's the one of the big reasons of the Japanese, 3 decades, under the water economies, and now we Japanese suffer the cheap yen. Everything is so expensive for Japanese tourists now, not only Singapore, everywhere in the world. But good bargain for you all. Please come to Japan now. And well, anyway, so which world you would like to aim? So yeah, that's my comment.
No.
So I think my views are quite clear. So if you want to have cheaper prices, if you want to promote social welfare, the best way to facilitate credit and to encourage companies to hire people and to preserve jobs only if a firm is worth more alive than dead. Otherwise, the company, unfortunately, and this is what Douglas Baird said. So unfortunately, I mean, life out there in the market is tough. So it's very tough to remain competitive in the marketplace. So unfortunately, you have a very nice bakery, but then you have a big supermarket offering bread at a cheaper price and better. So I mean, I'm so sorry for your bakery. So we should provide you with maybe other job opportunities, but that's how the market works. If we keep your bakery alive, that means that the whole population will be paying more for the bread just to keep your bakery alive. And actually, if we allow the supermarket to grow, they will be hiring sometimes more employees. They will be creating more jobs and more wealth. So just to clarify, we are on the same page on the ultimate goal. But if you ask Colin Mayer and Lucian Bebchuk, I'm sure they would agree that the ultimate goal is to make society a better place. But the question is, what is the best way to reach that goal? In my view, maximizing the returns to creditors.
Yeah, thank you. I think it's a very fascinating presentation and comments. I do agree that creditors should take control of the insolvent proceeding and the fate of the insolvent company, the future of insolvent company. Okay, so one thing I'd like to point out is that whether secure transaction regime is related to this one. So that the model law or the UN model law or from the UCC, United States, we know to some extent we may put workers, unpaid salary, have super priority position. That is one thing to protect their credit because they have a lower bargaining power. That is one thing, but just now you only gave us 2 choices. I want to have the third choice is that not 1 million or 1.5 million, but I want to know whether the creditors may have a stake if the company can still be a going concern after solve the financial issues. Okay, so we also know that in this situation there must be a new creditors want to inject money into the company, insolvent company, so that company can survive. Okay, so that will be all the situations that except for 1 million, 1.5, I want take 1 million and put a stake in the company. Maybe I'm betting that this company can survive. I can get more back. And the other thing is, if you are asking the creditor to protect the job of the workers, it may seem like that we are imposing corporate social responsibility on creditors, not the company, not the normal operating company. So that would be my point. Thank you.
Dan.
So a fascinating discussion. You all woke us up from lunch. So you're the king siesta breaker. So I just want to maybe push back. I never really thought about this until you started talking about it. But if you think of say China and strategic industries, right? So you could imagine that there will be, if China wants to say overtake the EV market, right? And so they funnel money into industries, and these aren't viable in the short term, right? But you want to get them to scale. And so they're not viable. You keep on funding, even though on a pure market basis they should be shut down, right? But you're trying to get, a certain part of the world market, for instance, which they've done to great effect, arguably, right? People would say they haven't done it, but I think a lot would say they have. So that would be one example, right, where maybe you would want to actually fund firms that maybe even for the first 5 years or the first decade are actually would go insolvent, right? Or another example could be, how about other industries which have great cultural value, right? So if you have, in Japan, I know Shishido Sensei is a lover of food, yeah. So you may have certain small restaurants that sell certain things, right? That you don't want McDonald's and Costco to be supplying you with everything. And so you pump money into a certain industry. It's maybe not viable. That's not the case in Japan. They are as a highly competitive, right? But you could think of a situation where maybe you want to preserve something because there's more than the economic value. So there is a societal value to keeping these companies solvent, which is not measured in maximizing the returns for creditors. Yeah, I don't know how I could forget that. Yeah. Yeah.
Okay, so maybe do we take the next question? Yeah, then we prepare. Yes, please. Okay, well, maybe in the meantime, okay.
Thank you for excellent presentation and the comments. I'm afraid that we are going into too much grand theories and grand worldviews on that. I mean, I thought that the issue was that how to protect the unpaid wages of the workers. And probably many jurisdictions has their own rules for that. For example, in Korea, in Chapter 11, the wage claims has a priority over the pre-bankruptcy claims. And in the context of the foreclosure of the assets of the debtor, the certain amount of the wage claims have the super priority for any other things. So even whether we agree to the scenario number 1 or scenario number 2, probably we can agree to a certain amount of that rule. I mean, do we really need go into the grand theory or the conflicting worldview to address this issue? That's my question.
Do you want to start?
So, we need not delve into the theoretical aspect as much. We need not delve into the theoretical aspect as much if you would want to talk about the legal provisions in that way, because I think almost all jurisdictions do afford some sort of relief to employees as creditors, and yes, and super priority is afforded, but what I would want to focus more is on the haircuts bit, because I don't know about other jurisdictions, because again, like I have maintained this, there's no data per se. I'm like, when it comes to India, I could find that stakeholder-wise data, which reflects the trends towards realizations and how admitted claims and the ones that have been distributed, there has been a substantial difference, in fact, if you look at the data. But not delving too much into empiricism, I would say we need to have that data to see that whether actually the reliefs are, trickling down, or is it just a lip service? Because we do enunciate the duties of directors, like we have the provision section 166 in India, which talks of the duties, and we have subsection 2 there, which talks about there's a entire enunciation of the duties that are owed to employees, creditors, then to the environment also. But is it just for the sake of it, or is it actually something which is working? So that is the bigger question, I guess, beyond, theorizing on the normative policies or the theories, or for that matter, any of the theories that we've been discussing. I would want to, yeah.
Yeah, actually, I have to say that probably the only point where we both agree is that employees, in their capacity of creditors with unpaid wages, they should always get a priority. I mean, that's very clear, but it's very clear in the law and economics literature. So Lucian Bebchuk and Jesse Fried, already in the 90s, they wrote this paper speaking about non-adjusting creditors. So I am a supporter, full supporter of giving priority to employees, and not only employees, also tort claimants as well. But what she's proposing is different. Is employees, even if they don't have unpaid wages, they should have an active role in the proceeding, and they should decide the fate of the company, basically. So I'm getting to Dan's question. So what happens if we want to keep the firm, even if that doesn't lead to the most efficient deployment of the debtor assets and therefore the returns to creditors? Well, I mentioned that there are some specific factors that might actually justify a deviation from the most efficient solution for the creditors and for society at large. One is, for example, think about systemically important financial institutions. Sometimes, if by not facilitating the reorganization of the company, you might end up creating more costs to society, maybe we might consider that, maybe. But if there is a sentimental value, my response would be, okay, who is going to be paying for the losses created by keeping a firm alive just because of the sentimental value to some people? The creditors, well, they are going to respond immediately to all solvent companies by increasing the cost of debt, making society as a whole worse off. The government, well, again, taxpayers will be the ones paying for that party, for keeping the sentimental value of one particular business. So that's why I think it's important to always consider this kind of pros and cons.
Yes, and that has happened. That has happened in India. That has happened much before the recent law came into being. I was discussing this with Aurelio yesterday also. So there was a landmark judgment rendered by the Supreme Court in India, and that I think that was about 30 years back, where this Kamani Tubes, it's one of the companies that was taken over and resolved by the employees themselves because of the sentimental value associated. And I'm not really saying that okay, you should go omnibus when it comes to incorporating employee voice in the resolution plan, because I feel that we need to learn and unearth practices in terms of how that has worked out for those jurisdictions that have actually incorporated such a mechanism. Like, Singapore has that mechanism. Vietnam also has that mechanism. India does not have, because I guess there's a lot of delay in the courts already. That was what I was mentioning already. And if you do, you are not really sticking to the model timeline that has been stipulated under the law. And if you incorporate one more voice mechanism, it may, have a spillover effect further, I'm saying. So you need to learn from different jurisdictions wherein such sort of a mechanism has been worked out and see whether it can be transplanted, because obviously legal transplants do have an inherent risk like that, because for whatever it be, the cultural value or anything that you would want to associate with it, but you need to be very careful before transplanting. So that's a tightrope walk, I would say.
Okay.
Thank you.
Thank you. And we'll let Surbhi have the last word. Okay. Thank you.
No, well done, congratulations.